Good afternoon, and welcome to today's webinar entitled Consequences of Juvenile Records. They are not collateral, and they can be forever. My name is Linda Rosen. I'm a Program Manager at the Office of Juvenile Justice and Delinquency Prevention. We're delighted that you've joined us today for the first in a series of planned webinars focusing on the collateral consequences that face juvenile justice system-involved youth. Today's webinar will feature Lyman lectures, Senior Director for the Casey Family Programs, and staff members at Georgetown University as facilitator, in addition to two presenters. The format for the webinar will include individual presentations, polling questions, and questions and comments from you through our chat window. During the webinar, we'll ask that you participate fully by responding to polling questions and utilizing the question and answer function. The polling questions will be viewable on your screen. Questions received through the chat window but not responded to during the webinar due to time constraints will be collected and shared with our presenters for their response. As soon as the responses have been returned, we'll post them to our website. We are planning a second webinar in April to address education for youth in confinement and important factors to be considered when working with this population. All of our webinars are archived online at www.nttaac.org. We'll begin our webinar in just a few minutes, but at this time I'd like to introduce Michelle Duhartong, who is a TTA Network Lead with the National Training and Technical Assistance Center, who will discuss logistical matters for today's webinar. Thank you.
Thanks, Linda. Good afternoon, everyone. Thanks for joining us today. As your host, I would like to take a couple of minutes to discuss a few features of Adobe Connect, which will help you maximize your opportunity to participate in today's webinar. To view the bios and photos of the presentation panel, please access the Word documents which are available now in the upper right quadrant of your webinar dashboard, the Handouts pod. The PowerPoint and Handouts is also located there for you to access. To use the chat feature, please direct your attention to the bottom of the PowerPoint screen. To the right of the PowerPoint, you will see a chat window. Please take every opportunity to network with one another, and this is where you will send your questions for the presentation panel. For those of you participating in today's webinar, please take a minute and help us count. Go to the chat window and type in the name of the person registered and the total number of additional people in the room with you today. This will help us with our final count. Again, if you're viewing with a larger group, please type in the name of the person registered and the number of additional people joining you today. Thank you. At the conclusion of today's webinar, you will be provided with a link to take a 5-minute online survey about today's presentation. We appreciate your feedback regarding the webinar, and this information is used to assist OJJDP in future planning and training. You will be able to access the link on the last slide of the PowerPoint. For those of you participating as a group member, please enter the link on the last slide in your web browser to share your feedback. Again, thank you for joining us today. Your moderator today is Mr. Lyman Lecters. He's the Senior Director of the Casey Family Programs, Senior Fellow at the U.S. Department of Justice. Lyman?
Thank you, Michelle, and good afternoon, good morning, everyone. I'm so glad you all have joined us, and it's certainly my privilege to be serving as your moderator for this pretty incredible webinar this afternoon. The topic, as Linda mentioned earlier, is consequences of juvenile records. They are not collateral, and they can be forever. We have two remarkable and well-versed presenters this afternoon, and I'll introduce them shortly. We did actually have a third presenter who, due to unforeseen circumstances, is unable to join us today, Ms. Linda Campbell, who works for the Public Defender of Philadelphia, and we will schedule her at a later date to join us and present her information. Our objectives for today include understanding the consequences of juvenile offense records, including sex offender registration notifications, and learning strategies to reduce the harm stemming from juvenile adjudications and records. All too often in the work that we do and the systems that we serve in, we see policies and practices that result in unintended consequences that have lasting impacts on those young people that we serve. And often those impacts last a lifetime and frequently are simply not good for the young people that we serve. Each of our presenters today is going to share for about 20 minutes or so. We'll pause after each presenter and answer some of your questions, and then we'll have some time at the end of the session for additional questions. And as Michelle mentioned, I want to remind everybody of the handouts pod where you can read the various publications that have been posted there and read the bios of the presenters. So to get us kicked off this afternoon, it's my pleasure to introduce you to Starcia Agu. Starcia is a research coordinator, University of Washington's Division of Public Behavioral Health and Justice Policy. Starcia is a remarkable young lady. She's got a compelling story and experience that she will share with you as she presents. Again, her bio is posted for your reading on your own. And with that, I'm pleased and honored to turn it over to Starcia Agu.
Thank you so much, Michelle, Lyman, and Linda. So good afternoon, everybody. If you had told me when I was 6 years old and living in homeless shelter after homeless shelter, or when I was 12 years old and living in a meth lab, or when I was 15 and standing before a judge facing felony charges of robbery and kidnapping, or when I was 20 and fighting the system to get the education I knew would be my only hope for a decent life. If you had told me then that I would one day describe my life as a success story, well, I guess just saying that's plain crazy doesn't quite go far enough. Impossible? That's closer. But here I am, and I'm proud to say that I am a success, even though I know I have a whole lot more I need to accomplish. When I was growing up outside of Olympia in western Washington with my mom, we'd live in different homeless shelters until my mom got mad, broke the rules, and they'd kick us out. Then we'd stay in our car or try to find friends to crash with. I'm the oldest of 4 kids. All of us have different fathers, which isn't surprising when you know that my mother would sell her body to make money or to get drugs. She'd always choose the most abusive men that she could find, and she never cared if they hit her or her kids. Moving around so much, I went to a lot of different elementary schools. I wind up with head lice so often that I'd miss out on months of school. My mother's anger was pretty constant. I called Child Protective Services all the time, or get my principal or teacher to call. It didn't really seem like anyone cared, though. They'd come and do a report, and my mother would just fool them. She was so system savvy, she knew just what to say, how to cheat on drug tests, and exactly how to scare her kids into staying quiet. We were not to trust authority, and if I did, my mother would beat me for it. She kicked me out when I was 11 years old and said that I was a burden and caused way too many problems. I didn't know where to go or what to do. My father wasn't really in my life, except when he came over to give my mother drugs in exchange for sex. My mother made sure that I knew that he didn't care about me. But when you're 11 years old, even a dad who doesn't care is a better option than living on the street. So I managed to find out where he was living, a meth lab near Olympia. I found him and threatened to tell the cops on him for cooking meth if he didn't let me stay there. I hate to say it, but living with a big-time drug dealer gave me a much better life than I had with my mom. There was always food in the refrigerator. I had money for school clothes and school supplies. There was always food in the refrigerator. I slept on the couch in the living room, and there were always people coming in and out to buy drugs at all hours of the night. I thought that if they wanted to see my dad bad enough, then they'd pay for it. So I started to charge them at the door. This was my first attempt to begin a college fund. You see, I finally realized that my life wasn't exactly normal, and I knew even then that education was a way out for me. I went over to my friend's house, and they'd all sit down and say grace and have dinner together, and I'd eat by myself while my dad made drugs in the shack next door. For the first time, I saw something that I wanted to have, and I knew I had to stay in school to get it. Our house got raided a lot. When the police busted in, they treated me just like they treated everyone else, throwing me to the ground and handcuffing me. I don't blame them. My dad finally did go to jail for a few days, and CPS just gave me to his brother, my uncle, who was also a drug dealer. My dad got bailed out of jail for $20,000 cash, gave me a Toyota 4Runner, a half ounce of dope, and $200, and said he'd come back. but he skipped bail and never did. I was 13 years old. I couldn't stay at my father's house because it had been seized by authorities as hazardous property, so I lived with my friends or in the occasional foster home, which I always ran away from, and even back and forth with my mom off and on. By then, I was smoking marijuana, popping pills, and drinking a lot. It wasn't escape. It was what I knew. When I was 15, my mother stole $5,000 worth of drugs from some people. They got their revenge by breaking into where she was living and tearing the place up. The woman who owned the house told my mother that she had to pay for it. When I visited my mom in rehab, she ordered me to take care of business, to get drugs and money and whatever it would take to fix up the house. I knew what she would do to me if I didn't try, so I did. That was the biggest mistake of my life. A couple of weeks later, one of the guys was picked up on another charge, and he told the whole story. He had said that I planned it all and that I was the mastermind. And at the age of 15, I was charged with 6 Class A felonies, and I took a plea. I had a declination hearing, but the judge saw a small glimmer of potential in me, and I was not tried as an adult. I got the equivalent of what they call juvie life, incarcerated in the Juvenile Rehabilitation Administration prison until my 21st birthday. My last year in custody was spent in what they call transitional care. I went to live in a group home, kind of like foster care, in Spokane. After I graduated, I applied for 35 jobs. At McDonald's, Burger King, I didn't care where it was. I got just 2 phone calls back, and of the 2 phone calls, I went in for an interview at the telemarketing. They showed me my office and gave me my hours, and I was so excited I got the job. But then they said, just one more thing. On the question about felony convictions on the application, you put down, we'll discuss upon interview. So discuss. I told them my story, and they told me goodbye. A couple of years ago, I wrote a letter to the judge who sentenced me, reminding him of the letter that I had written the day I was sentenced, setting goals and making promises. To date, I have done everything that I said I would do, plus a lot of other good things too. But I have more goals and more dreams. I want to work with youth to help them avoid the mistakes that I made. I want to help them to learn to value education and to understand that knowledge, education, and a degree are things that no one can ever take away from you. It's extremely difficult to work with kids in any capacity if you have a felony record as a juvenile. There must be reform so that juvenile mistakes won't have lifelong consequences for young people who have truly been rehabilitated like the system intends and are committed to turning their lives around. The stated purpose of Washington's juvenile justice system, and I imagine many others across the country, is rehabilitation. But even when a youth learns from their mistake, like me, many are forced to try to live as adults with the stigma of a juvenile record following them around. I was encouraged to apply for a pardon from our governor, Christine Gregoire, and the state's Pardon and Clemency Board gave me a unanimous yes. I knew a pardon would be a long shot for me, even though I believed the governor felt that I had something to contribute, because in 2009, the governor recognized me with the Spirit of Youth Award, which is given to juvenile offenders who excel despite their past mistakes. She also appointed me to serve on the Washington State Partnership Council on Juvenile Justice State Advisory Group, which, like other SAGs, advocates for juvenile justice reforms and best practices. For months, and I mean literally months, I called the lady in charge at the governor's office. Hello, Melinda, how are you? How's it going? Any word yet? Every single week. And then just 2 years ago, I got a call and I learned that I'm officially no longer a felon. I got my pardon. I don't know where I'd be today if people hadn't cared enough to work with me. You have the opportunity to open doors for countless kids, and there are thousands of kids out there waiting for people to care. Thousands of success stories waiting to happen this very minute. I'm never going to stop caring about them and fighting for them, and I hope that you won't ever stop either. This slide right here has my Dr. Loveridge from my graduation at WSU, research coordinator at UW in 2011. I do a lot of public speaking events, going to the universities and the community colleges and the facilities that, the detentions and the JRA facilities that have the kids in there. and tell my story in hopes to encourage them. And met with the U.S. Department of Education. I was the Models for Change, Champion for Change award winner this year. The Georgetown Training Institute, I just wanted to share some of the places that I go to talk about these issues. Really, I just feel like it's my obligation and duty to talk about my experiences, because when I was incarcerated, nobody told me the difference between conviction versus adjudication, and the average person who doesn't work in the juvenile justice field really doesn't know the difference between them. So I feel like it's my job to educate people about the kind of kids that we have in our system, that they're not just bad kids or bad seeds or going to end up in our adult system, that if someone gave them a little love and support, that they can do it too. And oh yeah, I'm the only juvenile ever in the state of Washington to receive a pardon from the governor. And my favorite day in Olympia, every year we go down to the Capitol and we have Youth Advocacy Day. And on the handouts attachments there are several documents. One is how juvenile records work in our state. One is called the Youth Opportunity Act. We're only one of 8 states that have open juvenile records, and we're only one of 2 states that actually make a profit off of them. And I feel like this is the year, I hope anyways, we've been working on it for a couple years, but I hope this is the year that the bill will pass so that we can stop our state from selling and distributing them, so that when young people get out, we actually really do give them a second chance by allowing them to get gainful employment and housing and education. George is going to talk about those 2 slides. And right now the University of Washington is thinking about adding these 2 questions on the college admissions application, and we have created a coalition, a little group of us, to tell them that we don't think it's a good idea, and we hope that we're going to stop it from happening. And then Lyman, do I just questions?
Yep, thank you, Starcia. A compelling story as always. I really thank you for sharing it. Thank you for sharing not only your experience, but also your passion for the work and for moving this forward. We are going to take a couple of minutes for questions, and so far we haven't seen any come through. So for participants, I encourage you to use the chat box to forward any questions that you have for Starcia, and we'll try to answer as many as we can. In the meantime, Starcia, you have shared some wonderful information, and I'm curious if you might have 2 or 3 recommendations. We have a very eclectic group of folks on the call from all over the country, administrators, practitioners, advocates, folks from the legal system. Share your top 2 or 3 recommendations that you'd like to have them hear.
Okay, I'll answer that, but I just want to make sure too that I say the way that it works, because I didn't say this, so sorry, but basically on the question, have you ever been convicted of a felony, the statute, our law says that you're only convicted for sentencing purposes, otherwise you're adjudicated. So on the question, have you ever been convicted of a felony, legally you're allowed to say no, but then you would do a background check, and now you're a liar and you're a felon. But if you mark yes, then you probably won't get an opportunity to even get an interview. So I wanted to make sure that I clarified or explained that. And then George is going to talk about who typically buys them. My 3 recommendations. The first thing is that we really have to do, as advocates and policymakers, we have to communicate to the community and to society and even to policymakers too about the kind of kids that we have in our system. We have so much research that talks about 50% of our population being dual system kids and having severe mental health issues and being traumatized and substance abuse, and people really view them as super predators, and it's public safety why we're locking them up. But so I guess my recommendation would be we really just have to educate people about the kind of kids that we have in our system and really encourage people to welcome them back in the community instead of giving them that label as being a felon, not giving them a job, and then wondering why recidivism rates are so high. My second recommendation would be, it to this day makes me crazy. I'm totally mind-boggling. I don't understand how we can make a profit off of juvenile records. And in our state, they won't necessarily admit that they sell them because it's in a bulk data dump, and there's actually not that many juvenile cases compared to adults. It's only about 26,000, I think, a year. But I think that's just outrageous. And then the third thing would be, since we are one of the minority states that have open juvenile records, that we do not electronically disseminate records, because we're just doing is, we know that if you put information on Facebook, once the information is out there, you just can't get the information back. So I don't think that there should be electronic distribution and mass dissemination of juvenile records. I think they should be treated just like dependency cases and involuntary confinement cases that are, they are open hearings, but the case record is not available online.
Great, thanks, Starship. One additional question as questions continue to come in. You've put several handouts and documents on the handout pod. I'm wondering if you would just take a moment to describe those handouts and share with the folks on the call what they have, what they're looking at.
Yeah, so the first one I believe is our PowerPoint. The second one, the Juvenile Records Bulletin. I'm so excited to share with you guys that our Washington State Partnership Council on Juvenile Justice, that's our state SAG, has kind of taken this issue on and has created a bulletin about how records work in our state. There's also citations of the other 7 states that have open juvenile records, and there's a lot of stuff in there about the history, how we got to where we are, and where we would like to be. The fourth one is the the DSHS letter. Our DSHS, our child welfare system, has wrote a letter recommending that they support our bill to stop our state from selling and distributing records. And this is just so huge because in past years we've had so much opposition because people didn't really understand the issue. So George and I and several others in our coalition have really been going around and educating people about how it works through the radio, the news, newspapers, pretty much anyone and everyone that will listen to us. And then the fourth one is it's a one-pager about exactly what our bill would be doing. We're calling it the Youth Opportunity Act. The fifth one, it says HB 1651. That's the Washington Defenders Association's position paper. I just wanted to make sure that I give you guys a lot of resources so that you could really understand the issue. And yeah, that's all my handouts.
Thanks, Darcia. We have another question that's come in, and it goes like this. For formerly incarcerated youth with a record, but who are currently looking for a job, how would you advise them to describe their situation to a prospective employer? You talked a little bit about how to check the box and what the response is if they check a box a certain way, but what would be your advice to them as they're describing their situation?
Well, I tell the youth that I work with a couple of different things. We do a lot of mock interviews. I make sure that they go in really very well dressed and prepared. And but I tell them on the application to put to mark the box no, because legally that's what we're allowed to do. And I get some of the same like the Juvenile Records Bulletin. We didn't have that. It's really new, but we have a couple of other one-pagers that I give them to explain about how records work in our state and what a juvenile record is, so that if they do mark the box no, and then in the interview they say, you mark no, I just want to double check or something, then after the interview they have that opportunity to be able to talk about it. The other thing is that once they get the job and then a background check comes back, I encourage them to contact like Team Child or other attorney advocacy organizations that can work with them, because technically we're not supposed to be discriminating against youth because of their juvenile records. So.
Thanks again, Starsha. We are now going to post a polling question for all of the participants. Please watch your screen and respond to the polling question as it comes across. We'll take a couple of minutes to do that before we move into our next presenter. Thanks everybody for responding, and as I suspected, there's a very broad group of folks from across the country who are participating, and I thank you all for your participation. Please join me in thanking Starcia. She's going to stay with us through the rest of the call and be available for some questions at the end of our time. Again, her story is compelling. It's pretty profound for her to be able to share her story, and her path and journey is remarkable. So we're all expecting incredible things. Actually, she's already doing incredible things, but we're looking for more incredible things from Starcia. So thanks again, Starcia. It's now my distinct pleasure to introduce our next speaker, George Giannakis. And George is someone who I've known for many years, in fact, more years than either of us would probably like to admit. We've worked together in different venues. George is currently serving as special counsel for Team Child, a civil legal services firm in Seattle, Washington. He's served in many facets as an advocate, an attorney, a defender, and one of the key leaders in the juvenile justice and child welfare systems in Seattle. I consider him a friend and certainly an expert. So with that, it's my pleasure to turn it over to George.
Thank you, Lyman. And we have known each other for many years, and I can honestly say we've only really had disputes in two courts, the juvenile court and the basketball court. Other than that, I think we get along real well. Starcia is an incredible young woman. I've known her for 4 years. It's a hard act to follow. The amazing policy work she's done in our legislature is unequaled by any paid lobbyist in the state. She has just done a remarkable job in expanding the scope of juvenile record sealing, bringing up this issue, making it raising the awareness among our legislators. You know, I'm unaccustomed to appear on the national broadcast stage. I feel sort of like Robin Williams' character, Adrian Konauer, in Good Morning Vietnam, but without the backup music. I couldn't think of what type of music would work behind me here. You know, I'm sitting in a conference room with 20 empty chairs, imagining what it's like in the other 200 people that are listening. Thought maybe we should have some music, but you know, I'm stuck on the Rolling Stones. All I could think of was Give Me Shelter. I'm sure there's a lot more better music genre to get into, but you know, I just can't understand a lot of the lyrics in rap. Any suggestions that you have, feel free to type them in, and I'll see if Starcia can cue them up on her iPod. I hope to have a lovely, smart, and talented Lisa Campbell from the Philadelphia Public Defender Office here today with me, but due to technical difficulties and some disagreement with our host over possible content of our PowerPoint, we weren't able to present her information, so we won't be talking about sex offender registration nor SORNA today. You know, SORNA is, for those we will touch here, SORNA is the Sex Offender Registration and Notification Act, and the office that's required to police that is the SMART office, and I'd be happy to make a special award if anyone wants to type in for me what the acronym SMART stands for. So we decided to cut out the sex offender registration from today's presentation, and we'll try again later and perhaps do a point-counterpoint type of presentation. But moving on here. So we're talking about what were formerly called collateral consequences. I think I've stopped using the term collateral to describe the consequences of juvenile adjudications. The Supreme Court of the United States in Padilla versus, it's on my brief somewhere on Padilla, and the Washington Supreme Court in State versus Sandoval made it real clear to me that consequences other than your typical, the number of detention time, probation, restitution, fines, other consequences that more or less spill out or probably more accurately seep out of juvenile adjudications are not necessarily collateral. So who has to explain the consequences of a juvenile adjudication? For the most part, that's been left to defense attorneys, and in the major cases on this in this area, defense attorneys have been either found ineffective or accused of malpractice for not explaining consequences, and as a result, clients who are not advised of the consequences, and we'll talk about what those other consequences are, have been able to withdraw their guilty plea, seek new trials. I looked at it looks like defense attorneys are far outnumbered in this audience here. But who else explains consequences? Probation officers do. I know they sit down and talk with them. In fact, probation officers in our jurisdiction have been misinforming juvenile offenders for many years about how long their juvenile adjudications will exist. I'll also say that judges have joined them in that, and defense attorneys. We are pretty sure that prosecutors don't have any responsibility in this, but someone has to explain the restrictions or consequences to the offender before the resolution of a case. So we have defense attorney's responsibility as required by the U.S. Supreme Court in Padilla versus Kentucky, where a legal resident was not advised of the consequences of his pleading guilty to a charge, was then deported, and was able to withdraw his plea after the Supreme Court had ruled in his favor, and basically said, you know, call it collateral, call it direct, it's a consequence of adjudication, and the defense attorney has to explain that to them. It's an alien concept for a lot of defense attorneys, never even thinking they had to know immigration law. A quick update on Padilla. The Supreme Court of the United States yesterday, in a case, and I believe it's CHILDE versus an Illinois case, upheld Padilla, but decided that it wasn't retroactive. So in that case, Mrs. C had been a legal resident and had been, she'd been a legal resident for many years, was convicted of a crime, pled guilty, was given a suspended sentence of over 365 days, the magic number in immigration law, as many defense attorneys are finding out. Then applied for citizenship, and she was denied citizenship, arrested, and deported because she hadn't been advised of her immigration consequences of her plea. The U.S. Supreme Court yesterday said, you know, if this had happened after Padilla, there's no question she would have been able to withdraw her plea, but Padilla is not retroactive. So for all of you defense attorneys who are wondering about all those clients you had not advised for many years, you're off the hook. And I'm off the hook. I didn't know anything about it. We also had another case in Washington that said it was a defense attorney's responsibility, and that was a state case, State versus A&J. In that case, an overworked public defender pled a 13-year-old boy to child molestation, a felony sex offense in Washington that requires lifetime registration, has to exclude you from the school that you're going to, and the Supreme Court looked at the case. As I said, the 13-year-old pled guilty. The Supreme Court found among the errors in deciding to reverse the guilty plea, decided that the attorney had not adequately explained the consequences of pleading guilty, even though these were not direct consequences. And they were on the plea form, but they hadn't been explained to the client. There were some other problems with the representation in A&J. The defense attorney had met once with his client for somewhere between 15 and 20 minutes with the client, with his parents, never met his client alone, never did any investigation. So there are a number of problems, but one of the holdings in the case was that the defense attorney had failed to adequately provide an explanation of the consequences that stemmed from the pleading guilty to a sex offense. One remarkable case, State versus XREL KM, a Utah Supreme Court case, 2007, almost the same fact pattern as the State versus ANJ, but it's in Utah, where a defense attorney again pled a young boy, I believe it was a boy, guilty to a felony sex offense that required registration, required school limitations, required counseling. The Supreme Court, instead of examining the role of the defense attorney or the prosecutor, decided that it was the judge's responsibility to ensure that justice would be done and that the judge had the obligation to explain all of these consequences if he believed that no one else had. And although you can't find the judge to be ineffective, the court, and there's no bar association penalties for that, the judge was held to have not adequately advised the client of his constitutional rights and of the consequences of his guilty plea, and the case was reversed. Only case I've ever found that a judge has ever been held anything like that. The effective disclosures are not made. So the Supreme Court in Padilla and the Washington Supreme Court in ANJ made it clear that you could withdraw a guilty plea if there had not been an adequate explanation of the consequences. Or you could get a new trial. You could withdraw the plea and then ask for a trial. That's what happened in ANJ. The young boy had new representation. After the plea was withdrawn, he went back to court. Case was set for trial. The new attorney investigated the case, met with the client, met with the witnesses. The prosecutor decided to dismiss the case after realizing that the witnesses had conflicting testimony. Dismissal of the charges, and the attorney can be found ineffective. And in the case of ANJ, there is a claim now that he malpracticed. That hasn't been decided yet. So Starsa alluded to this issue, and this is another consequence, and it's not unique to Washington. I think it's an issue that's growing all across the country, and that's the electronic distribution of juvenile court records or publication of these records to the internet. Well, tell me, how does that happen? So in Washington State, and I think this is pretty common, your state patrol or some other law enforcement agency holds all criminal records. So in Washington, if you want to run a background check on a person, you have to pay $10 to the Washington State Patrol, and they will provide you with any records they have on the person you're interested in. The distribution of records by the Washington State Patrol is restricted by statute, and it's very limited as to what can be released and under what conditions. They purge their records regularly. I can't say there's no inaccurate records, but there's very little chance of inaccurate disclosures. But in Washington, as I think in all states, some type of administrative office of the court, some part either of the Superior Court or of the Supreme Court, collects all state records electronically. And I think this has been growing and growing as the use of electronic records in courts has grown. I don't know what it's like in all states, and I apologize for not running a quick national search, but I'm pretty sure virtually all states now have a collection of all court records. So in Washington State, our administrative office of the courts, which collects all civil, criminal, juvenile, probate, all records, all court records that come from the courthouse, they collect them and then they distribute them. They sell them to some credit reporting bureaus, and we'll talk about that in a second. They send it on to the FBI, and they publish it to the internet. So anyone can go on the internet to the Washington State courts, look up a name or by a cause number, and find all the court documents. Can't find necessarily what the result was, but you see what the charge was, whether it was an adult or criminal. There's some information there. And if you go to that site, before you can get access to the record of an individual, there's a disclaimer that says this information may not be accurate. That's about 10 different disclaimers saying, we really don't know if this is accurate or not, but we're putting it out there, and you should double check anything before you use it. But of course, everyone just goes to the bottom, clicks I agree, and moves on and looks at whatever they were seeking. So we have the Administrative Office of the Courts in Washington sending out this information, and this is part of the legislation, I think, that Starsha was talking about, the Youth Opportunity Act, is attempting to limit the Administrative Office of the Courts to effectively have to be as, effectively to make juvenile records confidential. So in Washington, our Administrative Office of the Courts has a contract, and they sell all court records in what Starsha described as a batch dump, a data dump. And that data dump doesn't distinguish between adult and juvenile criminal records. It does distinguish between civil and criminal, and probate and other things, but it doesn't distinguish between adults and juveniles. And they sell it to the three major credit reporting bureaus, Equifax, Experian, TransUnion. And those companies have a contract with the state, and they're required every quarter to update their records, to purge their records. So if you get a record sealed, that doesn't get sold in the next data dump because AOC will not sell sealed records. But they've already sold unsealed records, so they're already out there. The private companies that have them have to purge, so they can't you can't distribute those after they've been sealed. However, they can resell them to other agencies without any restrictions, and those other companies have no restrictions. So what we have is companies that come up like Criminal Super Search, AccuSearch, Intelligent Investigations, Landlord-Tenant Search. You've seen these all over the internet. In fact, half the ones that I have up here now have already gone out of business, and there's new ones to replace them. These companies that are contacted by landlords, by employers for background checks, get the records, buy them from LexisNexis, the credit reporting bureaus, and they're free to distribute old records. They're free to distribute records that they have that are now sealed, but they don't have to know that. That isn't an issue for them. They just have those records. So we're one of the, I think, 8 states where our juvenile records are published. And it's an irony because when we adopted sealing, expunging, and destroying, let's see if I can just go on for a second, I'll come back. We have a statute in Washington. It's passed back in, when we adopted our Juvenile Justice Act back in 1977, in response to the Galt decision some 10 years earlier, which provided due process for juveniles. One section talks about sealing records. And it says, if a court grants the motion to seal, thereafter the proceedings in the case, in that juvenile case, shall be treated as if they never occurred. And the subject of the records may reply accordingly to any inquiry about the events record, the subject being the respondent. And any agency shall reply to any inquiry concerning the confidential or sealed records, that the records are confidential and no information be given out. Well, ironically, our Administrative Office of the Courts follows this, and if your record is sealed, they'll take it down off their website. Problem is, it was already up on their website. It's out there, just like your Facebook pages. Someone can just copy it, and it's out there forever. And despite the belief by some of the internet privacy companies that they can somehow purge your name off the internet, I haven't been able to see it done in this context. So let's see, we go back to this one. sealing, expunging, and destroying. So your state either has a way of sealing records, expunging, or destroying records. In Washington State, from 1977 to 1987, our records were automatically destroyed. You turned 23, your felony came off your record. 18, your misdemeanor came off your record. And it hadn't already been released on the internet because in 1987, our courts didn't have that capacity, which they do now. 1987, the legislature changed the law and decided that juvenile records would not automatically disappear and you'd have to request their sealing upon a motion. And for a time being, about 5 years up until Starsha worked her magic with the legislature, certain juvenile offenses, Class A felonies, could never be sealed. Starsha was able to get that changed and has benefited many juveniles. And I don't want to tell you how many years I tried to get that changed with no luck at all, and Starsha was able to do it in 1 year. So in Washington, we get to that situation that Starsha was talking about when you go for a job application. We know that sealed records can be viewed by prosecutors, police, FBI, court clerks, but they're not released to the public. A new juvenile conviction or an adult felony charge will result in nullification of the sealing order. So our record hadn't been destroyed, it comes to life again, it springs to life. They just changed its category. And sealed records can still show up, and as explained, the fact that they had once been on the website makes them live forever. See, I thought I had a few more things to say, but I guess I'll stop it there, Lyman.
Great. Thank you, George. And just for those of you who are wondering, George won all the battles in the courtroom, all the battles on the basketball court.
You wish.
We have some questions, and George, there's a couple right here for you, and then Starsha, hang on because we've got a couple that are coming in that we want to include you in on. So George, going back to the question of sealing records and the ability for systems to sell or not sell, the inability to sell sealed records, why wouldn't all records be sealed, and whose responsibility is that to make that happen? Is it the attorney's responsibility? Is it the judge's responsibility? Who's required to notify the young person about their rights to have their records sealed?
So in Washington State, we don't have a statewide public defender system. We have 39 counties. Each county contracts with their own, either with a law firm, with a private attorney, or creates a public defender agency. And it's beyond the scope of representation, I think is the term that's used. Sealing records is not part of the scope of representation. And the reason for that is it takes a number of years before you can seal your record. So to seal a Class A felony in Washington, it takes 5 years from the time you're released from incarceration or detention, or if you weren't in detention, from the time you pled guilty. For anything else, B, C felonies, misdemeanors, it's a 2-year wait. And because of that, the contracting agencies, the counties, feel that they don't have to, that isn't something that has to come out of representation on the guilt or innocence of a juvenile. So we don't have a great holistic attitude or holistic environment in juvenile representation. It's pretty limited to the guilt and innocence stage. In fact, our attorneys don't even represent their clients in post-adjudication hearings. So it is it's the responsibility of the youth. Now, I will say in some of our counties, probation staff are very good and will assist the juvenile to fill out the paperwork, file the motion. In 3 counties in Washington, we have attorney volunteers and student volunteers from the law schools who perform that pro bono for any former offender that wants to have their records sealed. but it's not within the scope of representation of the juvenile defender. What's the other part of the question, Lyman?
Yeah, I do. I have a couple of more questions. They're coming in nicely. So for those of you on the call, please continue to send your questions in. They're great questions. George, are you familiar with any national efforts or national laws that are out there, or efforts at a national level to prevent the distribution or sale of juvenile records?
No, I'm not. This isn't an issue that most states most states take a different attitude towards juvenile offenders. If you successfully complete, your records are sealed. Montana's a state where, at 18, as long as you've completed probation and paid all your fines, the records are sealed, and they're not released ahead of time. Most states are like that. Washington's one of the few states that takes this really harsh attitude towards juveniles of, even though you've done your time, whatever, finished your probation, you still have this scarlet A, this stigma attached to you because of the fact that they wanted. I'm not sure what their motivation was. But I haven't seen any national efforts to prevent this. But as I say, it's not a national issue. 42 states don't do this. I'm afraid it may be a growing issue as court clerks see this as another source of income, or see that they can do it, that there is no law against it.
Thanks, George. The next question is for both you and Starsha. There was a question that came in really valuing both the rights of juvenile offenders and the rights of victims. In this discussion, what information, if any, do you all believe a victim of crime should have access to? George, you want to take that one first?
What should victims of crime have access to?
Right. What information, if any, do you believe a victim of a juvenile crime should have access to?
Well, in Washington State, juvenile courts are open. They're not closed hearings. They're open to the public. The press is in there. All the court records are public. They're available at the courthouse. They're available at the internet. So there's no issue in Washington about what a victim of a crime should have notice of. I think there's even some statutes that require notification to victims if a youth commits a certain type of offense and they get released from the juvenile institution. There has to be some notice to the victim before they're released.
Starsha, do you have any thoughts on that question?
I think that's an issue for the prosecutors and the victims assistance unit there. I don't think defense attorneys have any obligation to notify victims of. So.
Thanks, George. Starsha, any thoughts on that?
Not really, actually.
Okay, that's fine. Thank you.
Well, let me say this, when we did, Lyman, let me say this, but Starsha's, when Starsha was going for her pardon, one of the questions that we knew was going to come up was, how did the victim feel? I mean, this was a victim of an armed robbery. So Starsha reached out and contacted the victim, who then came and supported Starsha at her pardon hearing. So Starsha does have some feelings about that. She didn't want to try to slip anything by her victim.
Thank you. George, you mentioned that 42 states don't have this issue, or I think that's what your word. Can you tell us, besides Washington, what are the other 7 states that are selling records?
I can. I think Starsha can. She was working with some students I thought we were unique, but she was working with some students from the University of Washington Law School, and in their research they discovered that there were 7 other states. I see Florida's one right here.
Yeah, I was going to say all that information is located in the Juvenile Records Bulletin.
Okay.
on the handout side.
Okay, and just for the listeners, that juvenile records bulletin is in your handout pod. So it should indicate those other states that are having this issue. Next question. You indicated that businesses, and I think this is going to your discussion, George, you indicated that businesses who purchase criminal record databases from, says CRA, are not obligated to rely on the most recent database information. Wouldn't these organizations be subject to the same, I'm sorry, I don't know what this acronym is, but the same FCRA requirements as the CRAs?
I think the simple answer is no, because they're not, the Fair Credit Reporting Act, FCRA, has some specific requirements as to when you can release information, how long, after so many years you can't release it. But I don't believe that the other background check agencies are actually credit reporting agencies. And I did hear an interesting, our legislature had a hearing 2 years ago, and they brought in the lobbyists for the major credit reporting bureaus. And when asked, I thought that the lobbyist answered I was really surprised she was so frank about this answer. She was asked by one of our legislators, so if I wanted to get a sealed record, could I get it that you had in your possession, could I get it from you? And her answer was, you pay us enough and we'll get whatever you want. And I was stunned that she released that information. But it's true. They purge their records, but those records don't go away. And if someone really wants something and you pay enough, they'll give it to them. Because what's the fine that FCRA would stick on? It would give them. It would be minimal. In fact, I don't even think you have an individual cause of action there. We were looking at this a few years ago. I think it has to be brought by the AG of the Attorney General of your state. So there isn't much restriction. There isn't much protection in FCRA.
Great, thank you, George. We have exhausted the set of questions that we have had submitted from participants. I encourage folks on the call to continue submitting questions. We'll respond to them in writing. I want to remind folks that because of the last-minute change and not being able to have Lisa Campbell join us, we are going to organize another webinar in the not-too-distant future specifically focused on SORNA and the sex offender reporting statutes, and have another webinar that gets deeper into that question. I do want to thank so much George and Starcy, and actually before we end, I'm going to give each of you just a moment to say some final words that you might want to share with the participants. Please note that we do have the online evaluation. We want participants to respond to that. It helps us think through how we can improve our webinars and our resources coming out to you. And so with that, Starcia, please, do you have some final comments?
Yeah, thanks, Lyman. I just want to say thank you so much for all of you joining, and also encourage you, those of you guys who do work with youth, to make sure that you include them in the work that you're doing, whether it's policy. I feel like often we have all these conversations about kids and youth and truancy youth, but we never really bring them to the table. And so I just like to encourage you guys to make sure that you include them. And if it is possible, I was reading one of these other questions, is it possible, could OJJDP somehow link a requirement to the states to provide a written information regarding healing to all adjudicated youth to the JJDP core requirement? I love the idea. I don't really know if it's possible either, but I think that would be great.
Thanks, Starcia. George, final comment?
Well, I'd just like to reiterate or emphasize what Starcia said about involving youth in policy making. I think a lot of us, if you are ever called to go to the legislature, are often asked if you can bring a juvenile with you who can talk about an issue. Well, Starcia's gone far beyond that. She's been able to organize youth and provide an active voice, a voice that the legislature listens to. She's done an amazing job, and I just have to really commend her for that. One thing I should say, Lyman, is a couple of slides that were taken out were links to collateral consequences, although I don't like to use that term, direct consequences of juvenile adjudications in individual states. So if you're in California or Pennsylvania, there are excellent booklets and websites on collateral consequences in your state. Florida just published one. There's one from Illinois, and we had those in there, but they seem to have been taken out. So we'll try to see if we can work with OJJDP to get those up somewhere so you can link on to them. And if your state doesn't have a collateral consequences or direct consequences pamphlet or booklet, contact us. We'd be happy to work with you to develop one. They're not that hard to do. Thanks, Lyman.
Thank you, George, and thank you again, Starcia, and thanks to all of the people, all of you who have joined us, and just for a remarkable hour of discussion on this most important topic. It's been my pleasure to serve as your moderator today. My friend and colleague, Linda Rosen.
On behalf of OJJDP, I'd like to thank our speakers, our host, the National Training and Technical Assistance Center, I hope the ideas expressed to you will assist you to better understand the difficulty posed by juvenile records. Please take a moment to fill out the evaluation, which will pop up momentarily, in order to provide us with your feedback and any ideas you have for future webinars. For those who may have missed the opening remarks, I'd like to repeat that in April we hope to bring a second webinar addressing educational concerns for youth in the juvenile justice system. OJJDP is always looking for new and innovative practices to deliver quality services to youth involved in the system, and we continue to welcome your input and appreciate your sharing your ideas with us. This webinar, both PowerPoint and audio, will be uploaded onto the National Training and Technical Assistance website in a few weeks. Again, on behalf of OJJDP, thank you for joining us.